Welcome to our presentation on charitable giving and estate planning. I'm attorney Mary Kate D'Souza, founder and chief legal officer of Gentrio. Today, we're here to talk about how estate planning documents can impact your donations to charities. The first document I want to talk about is the power of attorney. A power of attorney is a document in which you appoint someone to serve as your agent or attorney in fact in regards to your finances. You can make this document as long-lasting or as limited in time as you want. You also have the option of expanding or limiting the authorities of your agent. And this is where it dovetails in with charitable giving. One of your options when you're creating your power of attorney is to choose or not to choose to empower your agent to make charitable gifts on your behalf. Now, if you're someone that regularly donates to a church or a charity of your choice, you probably want to authorize your agent to maintain that authority so that your estate, your assets can continue to benefit the charities of your choice in the way that you normally conduct your business. Absent that authority, your agent would not be able to give donations to your chosen charity. So when you're creating your power of attorney, you want to think about how much authority you want to give to your agent. Now, the other important estate planning document, as you can anticipate, is a will. A will is the document in which you distribute who you want to get what of your assets to your beneficiaries. Usually our beneficiaries are people and organizations that we care a lot about. So that's usually charities and our loved ones. Now, your options when you're donating to both a charity and specific people are to make specific gifts or percentage gifts of your whole estate. Or you could make specific gifts and percentage gifts of the remainder of your estate. These are your choices. Let's walk through them. Let's say that you have $500,000 when you create your will. At the time, what your plan is to give $10,000 to a favorite charity of your choice. But the bulk of your assets you want to give to your two children. Now, a number of years pass, and at the time of your death, all that's left in your estate is $20,000. What happens in this situation? If you have given a specific gift of $10,000 to your charity, then your children will only split the remaining $10,000. And that probably wasn't your intent. So this is an example of why it's important to constantly review your estate plan to see if it comports with what you want and what your assets are currently. I recommend that you do this on a yearly basis, usually around the time you do your taxes. So you have an opportunity to review what your estate plan is and what your current assets and liabilities are. Now, the example I just gave was that your children got very little because your estate had declined in value. But let's look at the opposite situation. What if from the time that you created your will, when you only had $500,000, to the time you die, you've increased in value, say to $2 million. But your gift to the charity is only $10,000. Now, in the situation originally, you were going to give $10,000 when you had $500,000. So it seems reasonable that if you have $2 million, you might want to give $40,000 or more. So again, the charity would lose out because you have not reviewed and updated your estate plan to reflect the fact that you have a larger amount of assets. So it's important to constantly review. Additionally, the will is an opportunity to benefit your charities through distributions, either if you want to say for a specific gift or the other way in which you would give specific gifts to loved ones and the remaining assets to your charity. Another consideration is when you create a revocable living trust. Similar to a will, you have an opportunity of giving specific gifts or percentage gifts on the full amount of your estate. It's up to you which way you want to proceed. What an important consideration is is what type of asset you're giving. There are significant tax implications and tax savings opportunities depending upon what assets you choose to give to a charity. If you give a taxable asset that normally your beneficiaries would have to pay taxes on to a charity, they would be exempt from that tax obligation because they're a not-for-profit. So in other words, there might be a possibility of maximizing your asset and the charitable gift in favor of the charity and minimizing any any tax consequences on your beneficiary. These issues are very fact sensitive, as you can imagine, and it would be important to discuss these issues with your tax advisor. These are the three major ways that you can contribute to a charity through your estate planning documents: through the power of attorney, through the will, or through a revocable living trust. We hope you consider donating to your favorite organization during this time of year, and especially in 2020, where the pandemic has wreaked rather harsh circumstances on individuals' living situations. Thank you for joining me today.